The Dangers of an Ethical Code by Jane Synder. The author examines ways in which ethical codes are at times misused and the dangers this poses for analysts, patients, and the practice of psychoanalysis itself. Case examples illustrate the use of a code to provide a basis or an excuse for punishment or revenge as a way of limiting the range of emotions aroused in the analytic session, as an instrument of state control, introducing a third party into the treatment, and as a means of regulating who may practice psychoanalysis and how it is practiced. Quote, God Save Us from the Innocent and the Good, by Graham Greene, The Quiet American. History is replete with examples of ruthless and violent undertakings in the name of moral superiority. The Crusades were ostensibly an attempt to conquer infidels in the name of God and the Christian creed. Hitler wanted to purify the Aryan race and spread morally superior values. Senator Joseph McCarthy sought to eliminate the communist anti-democratic threat with methods antithetical to democracy. In Salem, a coalition of good citizens and judges hanged witches to expunge the devil's influence from their community. Freud advocated self-knowledge through analysis as the path to a more flexible and autonomous ego able to freely choose on the basis of knowing itself, to sublimate instinctual desires, and to formulate an ethic based on connection to others, object relations, rather than narcissistic gratification alone. In Why War? Freud, 1933, notes, the psychical modifications that go along with the process of civilization are striking and unambiguous. They consist in a progressive displacement of instinctual aims and a restriction of instinctual impulses. Sensations which were pleasurable to our ancestors have become indifferent or even intolerable to ourselves. There are organic grounds for the changes in our ethical and aesthetic ideals. Of the psychological characteristics of civilization, two appear to be the most important: a strengthening of the intellect, which is beginning to govern instinctual life, and an internalization of the aggressive impulses, with all its consequent advantages and perils. Pages 214 to 215. As Freud knew, moral and ethical rules and codes can be wielded to promote the common good, or to express the very instincts whose discharge they are intended to regulate, particularly the aggressive instinct. In Civilization and Its Discontents, Freud, 1930, writes, what a potent obstacle to civilization aggressiveness must be if the defense against it can cause as much unhappiness as aggressiveness itself. Natural ethics, as it is called, has nothing to offer here except the narcissistic satisfaction of being able to think oneself better than others. p. 143. One need only think of the self-righteous moralist, eager to pounce on others' wrongdoing to demonstrate his own virtuousness, to foresee the dangers of an ethical code. In the hands of a zealot, a set of rules can become a formidable weapon. Durkheim, 1965. The French sociologist understood that rules, even appropriate ones, cannot be the whole solution, and that sometimes the rules themselves are the cause of evil. p. 374. He warned, as precise as the regulation may be, it will always leave a place for many disturbances. Page 365. Durkheim's 1957 solution was a new secular morality that acknowledged that we are not naturally inclined to put ourselves out or to use self-restraint. p. 12. He noted that morals depend on restraint. If we follow no rule except that of a clear self-interest in the occupations that take up nearly the whole of our time, how should we acquire a taste for any disinterestedness or selflessness or sacrifice? There should be rules telling each his duties in precise detail, having in view the most ordinary day-to-day occurrences. Page 12. Durkheim was arguing that employers and workers must, in their respective groups, impose restraint upon their special and selfish interests. Conflict will diminish and be moderated only when opposing groups work for the whole of society. Durkheim, 1957, argued that a rule is not only a habitual means of acting, but, above all, an obligatory means of acting. Page 4. He concluded that a moral or juridical regulation essentially expresses social needs. Page 5. But disagreed with Kant's argument that regulation belonged solely to the state because modern economic life is too complex for regulation by an individual. He used the occupational corporation or guild as an example of a historically tried and tested organization that had served an important regulatory function. p. 25n. Durkheim's point was that the occupational group should become the basis of an occupational ethic, for an occupational activity can be efficaciously regulated only by a group intimate enough with it to know its functioning, feel all its needs, and be able to follow all their variations. p. 25n. This understanding is the basis of professional ethical codes. Zaz, 1974, described psychoanalysis as a subversive enterprise since its task is to demythologize personal and social fictions. p. 60. The psychoanalyst true to the profession considers ethical questions from a full emotional and intellectual understanding of himself and the individual involved and refrains to the extent he is able from operating on convenient fictions or rules. Badiou, 2001, made a strong argument for the evil of an ethical code, noting it is often an instrument of conservatism and economic ethos, nihilistic and dehumanizing in its very nature. Through its general rules and tenets, an ethical code dehumanizes the individual and ignores the particular. Badiou wrote, "Ethics prevents itself from thinking the singularity of situations as such, which is the obligatory starting point of all properly human action. For to be faithful to this situation means to treat it right to the limit of the possible." Pages 14 to 15. When ethics is invoked, thought is suspended. As he also noted, ethics is thus part of what prohibits any idea, any coherent project of thought, settling instead for overlaying unthought and anonymous situations with mere humanitarian prattle. p. 33. More ominously, ethics can be used as an instrument of evil. Ethics feeds too much on evil, and the other not to take silent pleasure in seeing them close up in a silence that is the abject underside of its prattle. For at the core of the mastery internal to ethics is always the power to decide who dies and who does not, pages 34 to 35. Psychoanalysis, as a science of the individual and a process of truth-seeking, is, in this sense, inherently anti-code, anti-generalities, and possibly anti-ethical. Badiou emphasized that what distinguishes man from animal and victim is what enables man to be immortal. This uniquely human capacity is thought, the capacity to seek truth, to question the ordinary and accepted, to be open to the not known, whether it be in oneself, as in the unconscious, in the other, or in a system of knowledge. It is also the possibility of relationship and the artistic impulse. A code by its very nature may foreclose this open-ended questioning process. An ethical code may be rigidly applied as an authority coming from without when a situation is ambiguous or so emotionally arousing that emotions are repressed or otherwise blocked from conscious awareness, whereas thus has no emotional guide, that is not grounded in consciously experienced desire or true connection to the other. The code may be adhered to as a guide for action. This emotionally empty application of the code may prove ineffective or actually harmful in the same way rules for psychoanalytic technique may be ineffective or harmful when applied in a formulaic manner, missing the emotional point and establishing a sense of disconnection rather than connection. The patient may also utilize the ethical code as a third party in the treatment and invoke it as a weapon of revenge against a therapist who is not conducting the treatment according to the patient's wishes. Invoking rules to avoid feelings. Rules may be used to avoid feelings or as a substitute for feelings. An analyst working with a provocative patient who brought in sexually titillating material and invited the analyst to have sex with her felt disgusted and degraded, and reacted by making distancing communications to the patient. This behavior did not advance the goal of treatment to help the patient verbalize more. In another case, a patient constantly asked the analyst to hug her. After several attempts at exploration, the analyst, feeling beleaguered and trapped, employed a rule. By way of explanation, "I don't do that. It would not be helpful." The patient took this as a rigid rule used by the analyst blindly with no regard for her as a person. It would have been more beneficial to the patient to explore the request and help the patient voice new material. Beginning analysts in training often follow the rules rather rigidly to avoid feelings of inadequacy or helplessness or out of fear of feelings generated by the patient. For example, the technique of reflection, reflecting a question with a question, is sometimes misapplied in the attempt not to reveal personal information. When one beginning analyst was asked about his credentials, he replied, "What do you think I am?" frustrating and confusing the patient who had no idea. In this instance, the analyst could have explored the patient's motivation to know, asking how it would help to know, or what the patient was looking for. Some kinds of information, when given, can in themselves allay the patient's anxiety. Another analyst who felt overwhelmed by her patient's constantly expressed longings to be with her all the time remained disengaged, reflecting questions in a rote manner or continually asking the patient what she meant rather than using her frustration and increasing anger to formulate an intervention, e.g., asking what would be in that for me, or what makes you think that would be a pleasant experience, or simply exploring the idea in a detailed way. Should we move in together? What about our husbands? The power to punish. Given the roots of an ethical code in regulating action that is based on instinctual desire, there is the potential that the code will be misused in the service of the desire that is inhibited or in the service of some other desire. For example, in sadistic punishment of those who sexually transgress or aggressive punishment of those who are aggressive. In the guise of policing practice, ethics may be wielded as a weapon in the service of instinctual pleasure, e.g., killing off rivals, vigorously punishing transgressors, or joining with other like-minded professionals in forcefully eradicating deviators. For example, psychoeducational programs of court-ordered treatment for batterers are policed by state agencies, often staffed by former victims of partners who battered. These programs are intense and often entail a kind of battering of the batterer who must acknowledge his crimes and take responsibility. While battering is clearly dangerous and morally reprehensible behavior, it is usually part of a narcissistic character structure in which the batterer feels morally justified in his violent behavior, even construing himself as the victim. In fact, he is a victim in the sense that he is narcissistically dependent on his partner and blames and loathes the partner for this state. Although confrontation and psychoeducation do not work with the extreme narcissist, therapeutic efforts, which admittedly take time, are misunderstood and issued as too soft and unsympathetic, and are usually not approved by state agency staffers. If the personality has been organized around rigid control and condemnation of instinct, the appearance of instinctual gratification or transgression in the other will be experienced as threatening and may lead to action to eradicate using ethics as a weapon. A number of years ago, a state Department of Corrections, in order to expedite its workload, decided that probation and parole supervisors would serve as preliminary hearing officers for parolees charged with violating their parole conditions. Common sense judgment was to be used to assess whether the evidence in a parole violation would be upheld before the parole board, which handles all parole issues because an individual on parole is technically still incarcerated. Based on the preliminary hearing, a parolee can be held for weeks pending a full hearing. Generally, the cases presented were fairly clear, involving clear infractions of well-known rules, failure to report to the parole officer as directed, changing one's residence without prior notification. There was a case involving two parolees who had been seen by a hardline parole officer driving off together in a fierce rainstorm from their parole report sessions. Their associating with each other was a violation of their parole and was reported by the parole officer. The officer hearing the case was informed that on the basis of the report, one parolee had already been returned to prison while awaiting his full hearing. On the face of it, the parolee had violated the rules of his release, yet the charge seemed petty to the hearing officer. A dean from a local junior college testified that the defendant was an active student in good standing. The parole officer who brought the charge then testified as to what he had seen. He was asked about the weather that day and acknowledged that it had been raining heavily. The defendant then testified that he had been dropped off at the nearest bus stop because he was going in a different direction from the other parolee. The hearing officer ruled that the defendant had acted as any average individual would have, given the weather conditions. He was ordered released. Yet the hearing officer reported that he had agonized over finding a way to keep the decision consistent with policy, so it would bear legal, moral, and ethical scrutiny if examined. Is the rule of law sometimes a shield behind which people act on their unconscious fears and desires? In some cases, a more subtle but more dominant value system may be at work, a belief in the right to indulge one's impulses so long as these are not inconsistent with the prevailing moral values of the society or organization. In the following instance, ethics was used as a means of discharging feelings toward a colleague. Two analysts in training banded together to report an analyst whom they claimed had violated patient confidentiality because they allegedly recognized the patient's identity in a case discussion in a class. They insisted the analyst should be investigated. Exploration revealed that these two reporters felt burdened and uncomfortable with their supposed knowledge and were in a state of negative transference toward the training institution and possibly toward their own analysts. In addition, the presenter was an enviable person in many ways and received respect and attention from others. Their pleasure in finding her unethical was apparent. Exploration of what the two reporters wanted to accomplish was sufficient to inhibit their persecutory action, pleasure in transgression, and its punishment. In a famous case exploited by the news media in 1992, Margaret Bean-Bayog, a psychiatrist who worked for many years with a suicidal, borderline young man, was sued by the patient's family after he committed suicide. She employed unusual techniques involving action, for example, sending the patient a postcard signed, "Mom." The psychiatrist's personal notes, which included sexual fantasies about the patient, were stolen from her office. The case was sensationalistic. Bean-Bayog surrendered her license rather than go before the Medical Ethics Board, a hearing that was to be televised in a 700-seat auditorium and break confidentiality. She never admitted guilt and did not accept a settlement that would have led to a 1-year suspension of her license because she would have had to admit guilt. While her techniques were unusual and not sanctioned by the standards of practice, her intentions seemed constructive. She had received supervision on the case from well-known analysts. However, a witch hunt like atmosphere prevailed. The public was mesmerized, titillated by this case while morally sanctioning the psychiatrist for inappropriate behavior, a clear example of Badiou's point on the silent pleasure in seeing the transgressor close up. Bean-Bayog was pilloried. Some of the effects of this case on the mental health community are discussed in a Psychiatric Times article on the report from the Committee on Therapy of the Group for the Advancement of Psychiatry, 1995. After witnessing the fate of Bean-Bayog, therapists may well hesitate before treating a suicidal patient or any seriously disordered individual. She attempted a form of treatment she believed might be effective, a judgment apparently supported by those respected authorities she consulted. The take-home message is clearly not to treat suicidal or other potentially troublesome patients who are too unstable to be seen as outpatients and whose insurance coverage usually will not allow extended inpatient care. P.3. The code as third party in the treatment. Sometimes an ethical code becomes an instrument of state control, as when the state chooses to regulate professional practice. This may occur when either patient or analyst involves the state as a third party. Many states now regulate the use of the title psychotherapist. The advent of managed care has introduced third-party management into therapeutic relationships regarding aspects of the contracting process and sharing of patient-therapist information. The state has also become involved in regulating the limits of confidentiality when a party is considered at significant risk. This is evident in the Tarasoff decision, Tarasoff versus Board of Regents of the University of California, 1976, where the practitioner's duty of public protection was maintained over patient confidentiality. In this case, a university health service was held negligent for not warning the Tarasov family that a young man in treatment had threatened to kill his former girlfriend, Tatiana Tarasov. The young man's therapist had informed the police of the patient's intention, and he was hospitalized. The patient was discharged alleging he no longer planned homicide, and no further action was taken by the mental health service. Unfortunately, the patient did subsequently kill Ms. Tarasov. The duty of the therapist and the university health service to the public, i.e., the intended victim, was spelled out by the California Supreme Court, summarized in the statement by Justice Matthew Tobriner. Protective privilege ends where public peril begins, cited in Holmes and Lindley, 1989, page 180. But how do we know when and where public peril begins? Don't we usually know only in retrospect? We don't know what would have happened had the patient stayed in therapy and continued to discuss his homicidal intention, his involvement with the therapist, and alternative actions. What import did the therapist's rejection and calling in the police have on the patient's actions and desire to punish? Many states have adopted the Tarasov ruling, and it is part of many professions' ethical codes. The analyst, fearful of potential transgression and liability, may relate to this state-backed ethical code as a third party in the treatment, a code that specifies that the practitioner must report something immediately to an outside authority or to the potential victim, puts the practitioner in the role of social control agent, and usually ends the therapy. This case demonstrates the significance of a therapist's reaction to a patient's struggle with impulses. Fear of liability and proliferation of lawsuits are seriously affecting healthcare and mental health practice today. Practitioners sometimes operate out of fear of being found liable rather than out of what is in the best interests of the patient. This may lead in some cases to abandonment of the patient, a clear ethical violation. For example, a social worker colleague reported that she had met with an adolescent who discussed her angry feelings about her school and her wish to blow it up. Rattled by publicized school shootings, the social worker told the teenager to wait in the office while she called the police rather than more fully explore the adolescent's intentions to take action. Another supervisor reported that she was frightened of liability issues when working with suicidal patients, that the very mention of thoughts of suicide was enough to lead her to terminate the treatment and refer the patient elsewhere. Similar dilemmas regarding confidentiality and third-party involvement arise when a patient presents incidents of physical or emotional violence toward children. The state mandates that disclosures of such behavior be reported to a protective service agency. In addition to concerns about reporting on a patient, the analyst may fear that such action will result in the patient's leaving treatment rather than staying and working on developing more impulse control. Exploration with the patient, including questions such as, why are you telling me this? Should I report you? Would I be colluding by not reporting you? Should you report yourself? Should you be alone with the child? Should more family members come for sessions? Usually leads to productive discussion and decisions regarding action. Confidentiality. Sometimes state control mandates a breach of confidentiality. Sometimes it ensures it. Even the latter can be life-threatening. A man who came to see his probation officer revealed he was HIV positive. He was in a relationship and had fathered a child. His girlfriend, however, did not know he was HIV positive. He had also had sex with other women. The probation officer was constrained by confidentiality law from revealing the information the man had shared. As Holmes and Lindley, 1989, note, there may be a direct conflict between maintaining a confidence and protecting the legitimate interests of others. p. 177. This can be the dilemma in psychoanalysis. On the other hand, this probation officer's caseload included cases where confidences revealed that laws required to report because a law had been broken. For example, if a client indicated he was using drugs, the officer was obligated to report it. In another probation case, a woman in her late 30s had served 3 years for assault with a deadly weapon as a result of hitting her 3-year-old in the head with a mop handle and thereby causing a fractured skull. Upon leaving prison, the woman and her 18-year-old daughter moved in together. The mother was pregnant again and seemed to the probation officer to have matured a great deal. She was having trouble getting work due to her record and, ironically, was only able to get babysitting jobs. The state protective service system continued to monitor her and, in fact, took her baby after delivery. The probation officer felt this was unfair and was also faced with a dilemma when he observed the maturity of the woman and realized that the protective service agency was bound to call him to find out about her work. If he revealed her employment, she would lose her babysitting job. It seemed to him that the agency was not interested in an assessment of how she might have changed or how capable of parenting she had become. To see her as changed and capable would be a risk for the agency, given her past record, and could get them in trouble if she were to hurt another child. He was concerned that they were operating by projecting from the past rather than evaluating the client's current functioning. Then there is the case of Gloria, who entered the correction system when she was arrested and convicted for stealing furniture. Her attorney had insisted she plead guilty, although she was innocent of the charges, a victim of a legal system where problems are resolved with shortcuts to save court time. Gloria was given probation. In the course of seeing her probation officer, an analyst in training, a therapeutic relationship developed. This created a problem for the officer, who felt caught between his personal ethics, i.e. to be therapeutic, and the codes and laws imposed upon him as an agent of the state. At one point, Gloria threatened to kill her boyfriend. Another time, she threatened to kill her biological mother. The latter threat occurred after arrangements had been made for Gloria to meet this woman. Gloria had just learned that the mother she had grown up with wasn't her real mother. In each instance, the officer was mandated to report the threat. In neither case did he. In both cases, the probation officer helped her talk it through. When he was promoted, his new job did not permit him to see clients, yet he continued to see Gloria. One day, his supervisor told him he had to stop seeing her, and he reluctantly agreed. Gloria was furious. The probation officer had turned out to be just another man who had abandoned and betrayed her. These interventions by representatives of the state make little sense from a therapeutic standpoint. Whose interest is being served? In all of these examples, the probation officer is an agent of the state who is expected to follow codes that require him to treat clients as exemplars of the general rather than as individuals, and to enforce the law rather than work toward the maturation of each of his clients, i.e., their ability to accept responsibility for their own behavior and to live within the law. Ethics and revenge. Ethics-based accusations can serve a revenge motive. A training analyst of a particular institute was friendly with analysts in another institute. It was generally believed at the first analysts training institute that her institute was held in contempt by many members of the other institute. During a collegial discussion at the first analysts institute of a reported sexual abuse case involving an analyst at the rival institute, the training analyst first analyst became annoyed and said that her group shouldn't presume moral superiority. And she went on to claim that someone in their own institute had been sexually involved with the patient. This allegation led to great concern among her colleagues and an insistence that she reveal this ethical breach to the head of their institute. Upon discussion, she admitted that she had exaggerated an incident reported to her in supervision. An analyst in training had sympathetically touched the arm of a patient as she was leaving the office. If this was a violation of an analytic code, it hardly amounted to a charge of sexual abuse, as she had righteously alleged. In another case, a patient angrily left a session and treatment when the analyst explored his suicidal threat and asked if she, the analyst, should kill him. This intervention was made in order to reverse the direction of the hostility from against the self toward the analyst. When the analyst had earlier asked the patient to go for a psychiatric evaluation if he wanted to continue an analysis, the patient had refused. It seemed that the patient was attempting to provoke a forced hospitalization, an event that would recapitulate his mother's experience. His mother had been forcibly hospitalized numerous times for manic episodes. The patient did not show up for his next session. Some time later, he called the analyst to report that he had taken her advice and gone to stay with a relative. Some months later, the patient sent a letter to the analyst threatening to bring her up on ethics charges since the patient had recently been hospitalized and tried to commit suicide while there. The analyst invited him to come in to meet, but the patient said he was too frightened to come and that he was seeing another therapist. The analyst hasn't heard from him since. The analyst presumed that the patient was frightened of his own aggressive wishes toward the analyst, partially expressed through the accusation.